that is it was a piece of legislation that was passed in December of 2019, and it changed retirement accounts pretty dramatically. So if you have a retirement account like an IRA or a 401k, you've probably heard of the term required minimum distribution, or RMD. So for years, what that meant was that once somebody turned 70 and a half, if they had an IRA, a 401k, they had to pull money out of it, and they had to pay taxes. A very bittersweet moment, as I like to say, for senior citizens. You have to pull money out and you have to pay taxes. Now that 70 and a half age, that was raised last year to age 72. And as you may know, 2020, there is no RMD requirement. They waived it under the CARES Act that passed back in March at this point, I believe, or maybe it was April. There's no RMD this year, but when the RMD eventually comes back, whether it's next year or in the year 2022, you don't have to take an RMD until you are 72 years of age. Now, another change that came from the Secure Act is what we call the 10th year rule. Now, back in the day, if you had a retirement account and you left that retirement account to your children or to somebody else altogether, they could take that money and they could treat that account that they inherited kind of like their own retirement account. They could pull the money out very slowly over their entire lifespan. And it was one of the most popular ways that people would transfer money to their children. They do it through this inherited retirement account. Well, a lot of people made a ton of money, a ton of tax-free money off of this distribution plan, and Congress caught on. And last year, almost unanimously, they changed the rules. Republicans and Democrats alike, they all came together and they said, you know what? We don't want people inheriting their parents' IRAs and letting the money grow for another 30 or 40 or 50 years. We are going to change it so that that money has to come out by year 10. We don't care how you take the money over those 10 years, but the money has to be out of there by year 10. And just like how when you pull money out of your IRA, you pay taxes, the same thing applies for your kids. They pull money out of the IRA that they inherit, they have to pay tax on. And that's really what our presentation today is going to center around. We are going to talk about how to minimize taxation, how to make sure that these retirement accounts are secure. Now, all this being said, I meet with all different types of clients. You know, yesterday I met with a client and their estate was really interesting. It's something I see all the time, particularly our Southern California clients. Now, my client yesterday, they had a house, and I don't exactly know how much the house is worth, maybe $1 million, maybe $800,000. It was totally paid off, but they had the house and they had a little bit of money in the bank, like, you know, 50,000. I don't know if that's a little to some people, it's all very relative, but they had $2.5 million in retirement accounts, $2.5 million. So by far, the biggest part of their estate was in these retirement accounts. And under a regular estate plan, you probably have heard of this before, you generally don't name a revocable trust as beneficiary of a retirement account, and that is for tax reasons. So if they would have done, you know, a cookie cutter plan, just a really straightforward plan, they would have named their trust as the owner of their house would pass to their kids when they pass away, to their trust to their kids when they pass away. But the retirement accounts, if they did a really basic plan, it would just go to their kids. But a lot of my clients, they don't want that. They want some type of barrier, like a trust, in between their retirement accounts and their children. Now, they had a $2.5 million retirement account. That's pretty uncommon, I'd say. A lot of people, they have $1 million retirement account, maybe $1.5 million, or maybe 500,000. But I will say that a lot of folks out there, their retirement accounts are their biggest assets. It's worth more than the equity in their home. And maybe that's you, the person listening. Maybe it's not. Not all this stuff will apply to everyone. And not everybody has a retirement account at all. Like, I know for my parents specifically, they don't have an IRA or a 401k. My father worked for King County up in Seattle, and so he has a pension, and he has nothing to give away once he passes away. But still, these rules, they can benefit those who have saved up money themselves through an IRA or a 401k. So let's jump into how beneficiaries inherit. Now, under the new Secure Act rules, if you leave money to a spouse, your spouse can just roll it over. But what happens if you leave it to somebody besides your spouse, somebody like your kids or a sibling? Well, now we have this general rule, which says that somebody who inherits an IRA has 10 years to pull out the money. So I'm going to use a really basic example just to try to illustrate how this works. Let's say you have one child, you have a daughter, and you have $1 million in a retirement account, and you leave that $1 million to your daughter. Under the current rules, she has 10 years to pull out the money. So that leaves her with a few choices. She can take the money all at once. She can pull out $1 million all at once, or she can wait 10 years and let the money grow. A lot of people already are thinking about this. She can let the money grow, maybe it will double, maybe it will go up by 50%. And after year 10, when the $1 million is worth $1.5 million, she can pull it out and pay taxes then. Or she can take the money slowly every single year and pay a little bit of tax every year and let the money grow. We're going to come back to a more specific plan, but that's essentially it. She has those three choices. Now she has to make a choice. She has to elect to be treated as a designated beneficiary. You'll see that on the slide here. If she does not designate herself as a designated beneficiary, then she will have to take the money out in 5 years. So that's really the first step, electing to treat yourself as an elected or as a designated beneficiary. And that choice, it's not like you have 10 years to make that choice. You have to make that choice within a matter of months. So it's important that your kids know that they make that choice by the time they actually inherit. Now, you'll see here as well, exceptions to the rule. There must be an exception. Does everybody have to take it out over 10 years? The answer is no. There are 3 exceptions, and they're pretty narrow. The first one is going to be people who are up to 10 years younger than the original account holder. So, like, for example, that would be if you named a sibling. So I'm a good example of that. I don't have any kids yet. So, I have my spouse as my beneficiary, but if I didn't have my spouse, I'd probably have my siblings. And my siblings, they are both a couple of years younger than me, like 5 years younger than me, 3 years younger than me. And then I have one who's a little bit older. And so if I name them as my beneficiary on my IRA, when I died, they wouldn't have only 10 years to pull out the money. They could use their entire lifespan, and they could treat the retirement account like themselves. So obviously, I'm relatively young. I'm only in my 30s. If you're 70 and you die and you have a sibling who is in their 60s, then they're going to be able to use their lifespan to pull out the money. And their lifespan is still going to be more than 10 years. So that 10-year rule, you escape it if your beneficiary is someone like your sibling or your friend. They're within 10 years younger than you. So that's your first exception. Your second exception is going to be a minor child. So, plenty of the attorneys at our firm, they have minor children. I have friends who have minor children. And if they name their children as beneficiary on their retirement accounts and they pass away, the minor children, they have their life expectancy to pull out the money. Now, there is a twist. Once the minor child turns a particular age, once they reach the age of majority, and that's a range of age, it's not necessarily 18, it's somewhere between 18 and 26, then they have 10 years to pull out the money. But during those ages between or before 18 and 26, they have their life expectancy. And then finally, you have people who are disabled or chronically ill. They also have their life expectancy period to pull out the money out of these retirement accounts. They're not limited to this 10-year window. So what does that mean, disabled or chronically ill? Well, the regs, that's going to be like the fine print on this law, the Secure Act. They haven't come out yet. So it's probably a pretty narrow standard what disabled or chronically ill means compared to what you might expect. But that is the rule. If you are disabled or chronically ill and you inherit a retirement account, your kids this way, they can use their life expectancy, the average life expectancy, to pull money out, which just means they take the money very slowly. All right, I do have the first question. Let's see what it is. For spouse as beneficiary, the IRA account can be taken through life expectancy, right? And yes, that is correct. For a spouse, no matter what age they are, they can use their life expectancy to take the money. So if you're 80 years old and you have your $1 million, your $500,000, and your spouse is 78, you pass away, they can take money based off of their life expectancy at 78. And if you're 70 and your spouse is 80 and you pass away at 70, your spouse, they don't have to use their life expectancy. They can use yours. It's called the ghost life expectancy as the younger person. So yeah, for spouses, it's relatively straightforward. as straightforward as it can be. It's for these non-spouse beneficiaries. And eventually there will probably be a non-spouse beneficiary for you because one of you is going to live longer than the other. And a lot of people aren't married at all. So these three people here, and that's going to be people within 10 years age of you or older than that, minor children who are your children, and people who are disabled or chronically ill. They can use a life expectancy standard, not the 10 years. And let me stress that again, minor children of the original account holder. So that means you cannot leave money to your grandchildren and expect them to have their entire life expectancy to pull out their money. It only applies to your children. So if you have named minor children on your IRAs or on your IRA trust, it's important that you do a review so we can decide if that's actually the right thing to do. All right, so let's continue through. And a lot of our clients, I mentioned the word IRA trust, they use an IRA trust to inherit their IRA. So that client I met with yesterday, they set up an IRA trust to inherit their IRA. And why would somebody set up an IRA trust? Well, an IRA trust, it has a couple of different benefits that you don't get if you just merely name a beneficiary who's a human or your child. And I'm going to talk about each one of these, but we'll go through them first. The IRA trust, you structure a plan for the beneficiaries to withdraw. It provides asset protection. That's really the big thing. It allows you, the grantor, to control the money, to keep money in the family if need be, and it protects the IRA from divorce. We'll talk about all these things in more detail, but I just wanted to lay out why somebody would set up an IRA trust. Now, an IRA trust, this isn't as common as a revocable trust. There's kind of a rule in California. The rule used to be that if you have a house, if you have real estate in California, you use a trust because houses in California go to probate if you don't have a trust. That's the old rule. It's become even broader since then. And what I mean by that is a lot of people set up trusts just for incapacity reasons. They set up trusts so that they can, have their children take care of them if they become incapacitated. But really the fine line historically is if you have a house in California, you set up a trust. IRA trusts are not that clear cut. You don't set up an IRA trust just because you have a retirement account. You typically set up an IRA trust if you have a certain threshold of cash in your money or securities in one of these accounts. I think you start thinking about IRA trust if you have $500,000 going to each beneficiary, but that doesn't mean you necessarily do an IRA trust just because you have $500,000 going to each beneficiary. Maybe it's $1 million for some people. It just totally depends. And also at the same time, I have clients periodically who have young people as their beneficiary, people under the age of 30 or people under the age of 18. I have people all the time that have $1 million in an IRA and they have a 9-year-old daughter or a 7-year-old son. Those people should consider an IRA trust as well. So you can, hold that money in trust until they turn that certain age versus just giving it to them when they're 18 or giving them money to their guardian. All right, I do have another question here. Let me pull it up. It says the people who are up to 10 years younger can't be your children, right? Well, that's a good question. I can't say I've thought a lot about that rule because I don't think there's anybody out there who has a child who is 10 years younger than them or within that 10-year period younger than them. Maybe there are people like that. I don't want to spend too much time on it, but I appreciate the entertaining question. I don't think it really matters. When I say 10 years younger, in case you didn't understand, that means like if you're born in 1979, your person has to be born in 1989 or an earlier year. That's within 10 years, okay? So if you see what I'm saying there, it's really going to be a sibling most of the time. I hope that answered your question. All right, so I go back to my example from yesterday where my client's $2.5 million, and right now they have their 2 kids named as the beneficiary on their IRA, 2 kids. So each one of those kids, if they pass away, the parents, they're going to inherit $1.25 million each. Now, right now, if they passed away, they would just get that $1.25 million. It would become part of their estate. And that's a lot of money to just have sitting in your estate. The average inheritance in the United States, it's like $100,000, $75,000. So we're talking about just $1.25 million for each of these kids sitting outside. Now, when you name an IRA trust as beneficiary on one of these retirement accounts, you get asset protection. So how does that work? So on this hypothetical, I'm going to go back to them as my ideal clients because they really did qualify for an IRA trust. They name an IRA trust as beneficiary on their IRA after their spouse. So the money doesn't flow through until after they both pass away. And the money goes to this IRA trust and it sits there. And the kids are trustee on this trust generally, and the kids are beneficiary on this trust. So they each have their own subtrust on the IRA trust. The older child, the younger child, and they can pull out money as they want, and they can pay tax on as they want. They're both beneficiaries, so it's all up to them. But if they want asset protection, they can get asset protection. And that's because they can resign as trustee. They can resign as trustee, and all of our IRA trusts utilize what's called the trust protector. So Cunningham Legal usually acts as trust protector. We can appoint an independent trustee to oversee the distributions. And that would be because the beneficiary might be worried about asset protection. They might be worried that they're going to get divorced, or they might be worried that they're going to get sued. Maybe they're a doctor or an accountant or an attorney, some type of professional that faces, malpractice or any type of lawsuit. Number 3 cause of death in the United States is probably medical error. So a lot of my healthcare people, they set this type of stuff up for their kids. And this IRA trust, if they get sued, independent trustee doesn't have to distribute anything. There is that standard there that whatever is inside the trust has asset protection. And it's pretty darn good asset protection, even in California, which is a asset protection unfriendly state. Generally speaking, they're going to be good unless it's a claim for child support or spousal support. So if it's a lawsuit, they have asset protection. They use an independent trustee, they'll have asset protection. If it's a divorce, other than spousal support, child support, they will have pretty darn good asset protection. So that's the reason why people set up these IRA trusts, is because they want that layer of protection. If you don't have an IRA trust and it's just sitting there as part of your kid's estate, then that money is just going to be claimed if there's a lawsuit. It's going to be just like any other one of their assets. So it's hard to give yourself asset protection in California. You can provide that if you set up your trust the right way. Now, that's not the only benefit of the IRA trust. You also have the benefit of control. So we're going back to my clients yesterday. They leave money to their 2 kids. If they both pass away, this is California, the kids will essentially have to name their spouses, the kids are both married, as their beneficiary on the inherited IRA. If the kids just inherit the money without an IRA trust, they'll have to name their spouses as the contingent beneficiary on that inherited IRA, because it's a community property state. Even if they wanted to name somebody else, they will have to get their spouse's permission. It's a community property state, and that's a really awkward conversation for people to have. And it kind of makes the child, the inheritor, a bad guy. So on these IRA trusts, we write a specific rule. We say that if our child passes away before us, their share goes to their children, or it goes to our other child. We say that it's limited. It can only be appointed to somebody who is our descendant. So that means it can't go to in-laws. And maybe you love your in-laws, but the majority of my clients don't love them enough to want their money to go to them in the case their child predeceases them. They'd rather have it stay in the family. So on that same situation, like yesterday, 1.25 million, there's a chance their child dies within 10 years after they pass away. They can leave that money, or that money will flow to their grandchildren now, or to their other child. It won't go to the in-law. And it takes away that awkward expectation. I do meetings all the time where somebody just inherited. They come to the meeting with their spouse, of course, and I ask, where do you want this inheritance to go if you pass away? And most of the time, they better name the spouse that's in that room. Otherwise, it's not going to be good. If they say, oh, my parents would have wanted me to name my children or my brother and bypass you, it's not going to be a friendly conversation for most folks. A lot of people don't have that type of bravery as it is. So you can be the bad guy when you set up this trust and you give the rule to your kid that when they inherit, they have to name one of your descendants. All right, so that's your second benefit. And then final benefit, of course, is it's called tax bracket arbitrage, which means that you really get your kids thinking about taxes. So I talked about when somebody inherits these IRAs, they have 10 years to pull out the money, right? 10 years. And they can take it all year 1, they can take it all year 10. If they inherit $1 million and they take it out, they're going to have $1 million in income. And that's going to be bad, right? If they inherit $1 million and they wait until year 10 and now it's $1.5 million, they're going to pull it out and they are going to pay it on $1.5 million of income, in addition to what they make at work and what their spouse potentially makes at work. I have the tax brackets laid out for us. This is the federal tax brackets. So in my hypothetical, let's go back to my guys from yesterday, 1.25 million. Let's say they inherit 1.25 million, and they're both married, like I said. If they took 1.25 million, they're going to pay 37% on everything above 612. So they make money at work, and then they're going to pull out 1.5 million. The majority of their income that year will be taxed at 37% at the federal level. And this is in 2020. I mean, who knows what the tax brackets are by the time we all pass away? But I'll tell you what, it's very possible that the highest tax bracket is over 37%. There are a lot of people out there that want to raise this 37%. And even for those out there watching this webinar who are saying, oh, 37%, that's not that big of a deal, don't forget about the state tax brackets too. So in my same hypothetical, where you're pulling out 1.25 million, I mean, look, this is California. If you're a married couple and you make over $1,074,000, or basically $1,075,000, they're going to take an additional 13.3%. So 13.3% plus 37%, you're at 50.3%. And I don't know enough about it, but I did see that they did add that new tax bracket this year. I think it's for a wild amount of income. So it's not going to affect my beneficiaries inheriting 1.25 million, but who knows? I mean, they can raise taxes at a whim, right? I mean, it's California. I don't think that's even controversial to say. Now, I do have a question coming in. Is the IRA trust inside or independent of the parents' trust? Is the IRA trust irrevocable regardless after parents both die? This is a great question. The IRA trust is going to be independent of the revocable trust. There are some attorneys who will draw it up inside the revocable trust, but it's still a different trust. But the words itself will be in the actual same physical trust. We do not do it this way because we find it's too hard to administrate. It's getting easier than it once was, but we just prefer having it being a separate trust altogether. So technically speaking, it's always a separate independent trust. It's known as a see-through trust. It's different. It's a see-through trust. So the beneficiaries can be revealed to the IRS. That's why the taxation is a little bit different than with a revocable trust. But it still might be in the same binder, just depending on who your attorney is. But at Cunningham Legal, we do two separate trusts just to really draw that distinction. And then the second part of this is the IRA trust irrevocable regardless after parents both die? Yes, an IRA trust is irrevocable once both parents die. I mean, really, it's an irrevocable trust straight up. But there's nothing in it. The way the structure works, it's not like a revocable trust where you put your house in it. It's an irrevocable trust that is the contingent beneficiary on your retirement account after your spouse. And so there's nothing in it. You can change the trust as beneficiary until both people die. And then it's like the irrevocable trust, just like your regular trust that you have in place. And I really should try to draw this distinction for people. Why is it that we don't just name a revocable trust, like how you have your house in, as beneficiary on a retirement account? According to the tax rules, it's not a see-through trust, probably not at least. So what that means is if the regular revocable trust were to inherit an IRA or other retirement account, it would just automatically get taxed at the highest tax bracket. Trusts have narrower tax brackets than humans. After about $12,500 of income, you're at that 50.3%, the one I'm showing here that's at $1 million for California. So that's why you don't name a revocable trust. You have to use an IRA trust if you want to use trusts with your IRA planning. So that's a great question, and I know this is complex for everyone. You know, this is not something that you just totally learn in your first day of estate planning, but it really comes in handy because, like I said, a lot of our clients, their biggest asset is their retirement account, or it's definitely an asset worth protecting. So like I said, going back to this tax bracket issue, if you pull out all the money in year one, your 1.25 million, or even if you pulled out, less money than that, if you pulled out $400,000, you still be at that about 35%, at least 32% tax bracket. And that's not good, especially when you couple it with California. So really the best way to take the money is probably taking 10% a year. 10% a year. And every single year, and it gets a little bit bigger, it's a curve. It's hard to explain, I guess, over a webinar like this, but you do 10% the first year, you look what you have left, you maybe do another 10%, maybe you increase it over 9 years, so divided by 9, because you're trying to come up with that average. And you're always going to be bumped up a tax bracket, but you'll never be bumped up into the highest tax bracket. And you'll also be able to benefit from the compound growth in these retirement accounts. Because remember, they still grow tax-free. It's just the income that you take out that you have to pay. So even if you don't set an IRA trust, maybe if you have kids, you try to explain, hey, there's work to be done once you inherit. Don't just impulsively take out money or even impulsively leave it there. You want to really make sure you have a plan in place to inherit. Because if you don't, you could be costing yourself tens, if not hundreds of thousands of dollars. All right, so continuing on, IRA trusts, beneficiaries who inherit these trusts, they always have a plan. So I'll be free to admit, it seems like my clients who have a lot of money in IRAs, they usually have pretty good kids. I guess, if someone's able to practice delayed gratification, they're able to raise kids well. I'm not too worried about somebody having a reckless child who's going to pull out the money all at once. I mean, maybe, there are bad kids out there, people who don't think about financial consequences, but they just don't tend to be born of people who have $1 million in the IRA. And maybe that will get me canceled or, it's offensive, but that's just my observation. Now, either way, what I'm getting at is when you do have an IRA trust in place, it gives your kids a plan no matter what. And not everybody needs that, but like I said, talk with your kids, make sure they're in on the fact that it's not just like you snap your fingers and you inherit when you inherit an IRA. All right, every year we weigh income versus tax brackets to make sure that we are paying the least amount of tax possible. So like when you set up an IRA trust, every year we talk with the beneficiary about how much money you should pull out. So when somebody works with trust administration with us, we make sure that they're clear. We take a look at their tax bracket that they're in. We take a look at how much money they have, and we advise as to how much money they pull out. It's a pretty useful tool. Now, I'm going to do one more bonus. This is reducing state tax. So I'm going to make up facts from my client yesterday because I didn't go this detailed with them. But their kids, they inherit the $1.25 million. I do know they're California residents. Now, let's assume the kids don't want to be in California. They know they're not going to retire in California. They're here right now, but they're going to go take off somewhere. And maybe it's going to be Nevada or Texas or Washington or Florida, some state that doesn't have a state income tax. They can just leave that money in trust. If they're in a high tax bracket and they don't mind the trust paying taxes, they can just leave their inherited IRA money in trust. Now, they'll have to pay taxes on it as it comes into the trust. But if they're already in a high tax bracket, like a lot of my clients' kids are, they might not care. Now, if they do it that way and they use a Nevada trustee, then that trust, it's not going to pay California state tax. And when the beneficiary leaves California and goes to any other state, but especially, Texas, Florida, Washington, and Nevada, they can pull out the money and avoid that state tax altogether. I'm not going to spend too much time on this. This is a little bit more complex than everything else we're talking about. But basically, if you have a lot of money in an IRA and your kids are high earners, they're doctors, attorneys, something like that, entrepreneurs, then this is something definitely worth checking out to reduce state tax. Now, altogether, how do you avoid taxes? People come to me all the time and they say, what do I do to avoid taxation on my retirement accounts? And this is more for the average person out there. So most clients I meet with, particularly baby boomers, they have a traditional IRA. So traditional IRA, what that means is when you put money in there, you haven't paid tax on it. When you pull it out, you pay tax. Well, a lot of people of the younger generations, they do Roth IRAs. Roth IRAs came around in the late 90s. They really weren't widely used until early 2000s. And so it makes sense that a lot of baby boomers who retired 10 years ago or are retiring now, they just didn't want to start on a new retirement account, when they foresaw retirement so soon. Now, some baby boomers do have this in place, but a lot of people don't. And so that's who I'm talking to here. What a Roth IRA is you put money into a Roth account, money you already paid tax on. And when you pull that money out, no matter how much it grows, you're not going to pay any more tax. So Roths, they are a lot easier to pass to the next generation because there is no tax consequence, okay? Now, not only that, but with your IRA, your traditional IRA, you have to take an RMD once you're 72. They make you pull money out, like I talked about earlier. With a Roth, that's not the case. So on my perfect example of a estate plan, I would have a client with a good Roth account. So they'd have their traditional account, they'd have their Roth account. I'm not saying just do a Roth. You have a traditional and you have a Roth. And all that money in the Roth, that's the last money that my client ever touches, because this is going to be the easiest money to pass to a child. They just sit there living off their RMDs from their traditional while their Roth continues to gain steam. Hopefully it's invested like something like Apple, right? I bought Apple for $280 in December. It's at like $450 right now. Or maybe you're just invested in the S&P 500. But my point is, it grows and grows and grows. So then when you're 90 or 100 and you pass away, that thing goes to your kids. And your kids inherited the Roth, and they don't have the same analysis like they do with the traditional. They don't have to think, should I take it in year 1 or year 10 or a little bit every year? No, just do it in year 10, because they can take out $100,000 from a Roth or $1 million from a Roth, and they won't pay any tax. Who cares if they take out $1 million? It's not taxable. So what I'm getting at here is, if you are still working, try to set up a Roth. And if you're retired, consider doing a Roth conversion. I can't help you do a Roth conversion because I'm an estate planner, not a financial planner. But I can tell you, if you have a financial planner, go ask them about a Roth conversion. That is a really popular thing right now due to the CARES Act. The CARES Act lowered the standard on doing a Roth conversion. If you're already taking RMDs, just go ask them about it, because those are the people who are going to most effectively pass their assets to their kids without taxation. I'm not, once again, saying that a Roth makes sense for you. I'm not saying put everything you have in a Roth, but you should put something in the Roth. All right, I do see another question. Let me read the question. Okay, I do have this one answered. Excuse me. I see people raising their hand. You can raise your hand if you like, but let me just remind folks, you should see a Q&A box next to raise hand. If you click Q&A and you type in your question, I will generally answer it as we go through. I will allow for questions and answers after the presentation today. So once again, Roth conversions, I encourage them. If you're still working, do a Roth. I have a lot of clients say I make too much money to do a Roth. There are ways to fund a Roth, even if you make $2 million a year. It's called a backdoor Roth, stuff like that. And if your financial advisor can't do it for you without being too straightforward or too forward period, I think it's time to explore financial advisors who can, because that's how my clients are really saving money on taxes right now, is using a Roth. If you're planning for retirement and you're not using a Roth, it's not a great sign for your financial advisor. All right, so continuing through, I talked about the Roth conversion. So let's say that you have $1 million in an IRA. You can pull out $10,000 this year, pay the tax on it, put it in a Roth. There's no more RMD. You never have to touch that money again. It can grow, and then that money passes to the kids, and they can take it all in year 10. So instead of having, if you have a 20-year life expectancy, instead of letting that money grow for just 20 more years, plus your RMD, you can turn it into 30 with a Roth. All right, here comes the question. Here we go. Do IRAs and Roths both have to pay estate tax? Yes, they are both part of your estate. So that's a separate tax than income tax. Estate tax is a transfer tax. Now, currently, estate tax only applies to individuals with $11.58 million or more. $11.58 million or more. So if you're married, that's going to be about $23 million. So unless you're passing $23 million as a married couple to your kids, or $11.58 million as a single person to your kids, or whoever your beneficiaries are, you don't have to worry about estate tax. Now, all that being said, that estate tax number is the highest it's ever been. And there are a lot of people in this country who want that number to go down. They want it to not be 11.58. They want it to be maybe more like 3.5. It's hard to get a politician to really pin how much they want the exemption to be, but I don't ever think I hear anything lower than 3.5. It used to be 5. It's scheduled to go back down to 6 in the year 2026. But you guys all watch TV. You guys know how politics is in this country. I'm tired of making predictions. So just keep an eye on it. As of now, estate tax issues don't really affect a whole lot of folks. All right, so let's continue through. What does this all mean? What am I saying with all this good stuff? I'm basically saying, if you just have your kids named as beneficiary on your IRA or your contingent beneficiary, and you're just crossing your fingers saying, oh, it's very simple, that's not a plan. And not everybody spends a lot of time thinking about estate planning. Everybody's different. But I'm not even saying you should do an IRA trust. I'm saying that you should at least have a plan for your kids. You should at least talk to your kids about how to inherit, at least look up the rules, because this is a way to make a lot of money. You know, like a lot of folks, they'll spend hours working at a job on, you know, a trivial project or whatever, working an hourly job. Spend a little bit of time on this, and you could end up making a lot of money for your kids. And maybe an IRA trust makes sense. We do consultations to talk about whether it makes sense or not for you. All right, so what do I do now? So if you have an IRA trust pre-Secure Act, so pre-December 2019, you should have it reviewed, okay? Have it reviewed. Hopefully the change isn't that big, but you definitely don't want to cross your fingers and hope that it works. And if you don't have an IRA trust, we do complimentary appointments for the people on this webinar where we talk about potentially setting up an IRA trust and finding out if it makes sense for you. And what's a good clue? If your IRA is a large asset, you can set up an appointment and we'll talk about it. And when I say large asset, it's different. You know, my clients yesterday, 2.5 million, 2 kids, that's definitely a large asset, right? I think that's for anybody. If you have $1 million and 2 kids, it might make sense. I'll just tell you the pros and the cons. If your IRA is worth more than your house, it's certainly a large asset. That's going to be the biggest thing that your kids inherit. And there might be somebody out there who has a $300,000 IRA, but they have a special needs child. It might be important to look into setting it up. Or they have a sibling who they're worried about running out of money. They're worried that if they inherit their $300,000 IRA, they're just going to take the money like they won the lotto and run. These are the type of people who should consider IRA planning. All right, so look at your estate plan. Do you have the right trustees? Do you have the right beneficiaries? If you have retirement savings, contact your attorney. Make sure that you're up to date. Attorneys, financial advisors, CPAs, we talked about them on this webinar today. Listen to them because we should all be on the same page. Not everybody's created the same, like I said earlier, but that being said, it's important to make sure you are up to date because these rules, they do change. All right, so our team is here for you. Cunningham Legal, we help people update their estate plan. I see a lot of my current clients on this call today. If you want to do an appointment, we do offer appointments. Like I said, we have offices throughout California, Southern California, Northern California, Sacramento area, LA area, Orange County. Raise your hand, but please type in the Q&A box your question. I will answer it. I do see people with raised hands. I guess I will say their first name. I see Tony has a raised hand, and I think that's the only person left with a raised hand. If you want, you can put your question in the Q&A box if you haven't already, and I will answer. And if I don't get a question for, the next 60 seconds, I will end the presentation. I don't have any questions just yet. All right, I got a question. So if I have a Roth IRA, explain to me how my kids inherit the Roth IRA. Okay, so like I said earlier, Roth IRA, no taxes on it. They still have to take out the money within 10 years. If your kids inherit a Roth IRA, they still have to take out the money within 10 years. And so what that means is that they're going to have to make a decision as to how to take the money. But unlike taxable retirement accounts, they can just wait until year 10 because the idea is the money's going to grow. It's an investment. It grows over those 10 years. And then in year 10, they take out all the money and they don't owe any tax. So it is a simpler distribution plan than if you're playing with the whole tax bracket game and the state income tax and the federal income tax. And that's why I encourage people to do at least some Roth planning. All right. What other questions do people have? If I don't get a question in the next 15 seconds, we will wrap up. This presentation today, it should be made available on our YouTube channel. You can go to our YouTube channel, Cunningham Legal, check out all our good videos. You can go to our website as well, cunninghamlegal.com, and you can see our upcoming webinars. We have a lot of webinars upcoming. I am going to, I guess I'll stop sharing my screen. And I don't see any questions coming in. So I do appreciate everybody taking the time to be here today. All right, so like I said, I appreciate everybody being here today. I hope you all have a good weekend, and I will see you next time.